the first speaker. We have Nicole Boeckmann, who I'll give you the brief background. I like to give schools because you're teachers, right? You like to hear what schools we went to. And I saw someone with a University of Michigan sweatshirt. So I think you'll really like the fact that Nicole Boeckmann went to University of Michigan undergrad, Catholic University Law School. She was an ADA for 7 years, assistant district attorney, prosecuting, among other things, homicide, rape cases, robbery cases. In 2004, she became a federal prosecutor in the Eastern District of New York. And for over a decade now, she has been the chief of the Long Island Criminal Division of the U.S. Attorney's Office. So for any federal crimes on Long Island, Nassau, and Suffolk County, she's the chief on Long Island that would supervise all of those cases. So she has vast experience as a prosecutor, both at the state and the federal level, and we're really delighted to have her. So Nicole?
Yes.
Hi, thanks for joining us. I thought I would ask you to just start with something that the teachers may not be familiar with, and most of the public is not. But in our system, people think the judge is in charge of the sentencing. It's the judge who decides what the sentence should be. And as I described, that's true to a large extent, and we have a lot of discretion to do that. What people don't understand is what the role of the prosecutor is in potentially controlling that sentence, of either making sure the sentence is not too low or the sentence is not too high if you're trying to reach a plea deal with a defendant and the defendant is like, I don't want to plead because I'm worried the judge might give me too many years. So how are prosecutors able to essentially take power away from the judge and try to control to some extent or to a large extent what the ultimate sentence might be?
Yeah, so as you said, ultimately it will be up to the judge, but a prosecutor, through their charging decision and also their plea decision in terms of what crime they have a particular defendant plead guilty to. So there may be certain offenses, if you look to the white collar context, where we could plead a defendant out to a particular offense that would cap him statutorily at 5 years in jail. And those sentencing guidelines that Judge Bianco spoke about earlier, the guidelines may be in excess of 5 years, but by having him plead to the offense that has a statutory cap at 5 years, we're essentially dictating that he can't get more than 5 years in prison. Conversely, we could do that with an offense that has a mandatory minimum by not allowing a defendant to plead to offense without a mandatory minimum. If we're concerned and a defendant is charged with more than one crime, and one of those crimes carries the mandatory minimum, we could only offer a plea agreement where that mandatory minimum is in effect, and thereby sort of dictating that the court can't go below a particular number.
Let me just give an example of that type of mandatory minimum. I'm going to use the most extreme example, but it's not that uncommon. In a gang case, if it's a murder that's part of a gang under federal law, that there's a statute that if you're convicted of that carries a mandatory life sentence where you cannot get parole. There's no parole in the federal system. So if you're 19 years old and you're convicted of a murder in aid of a gang, you will serve the rest of your life in jail if you live to be 90, right? So the prosecutors decide whether or not to take that off the table and allow a defendant to plead to something less than that, or to insist, just say, we're not coming off of that, and the defendant would essentially then go to trial, right?
Yes, absolutely. That's absolutely, certainly one of the things with a prosecutor where discretion is really important, because you have to weigh all of the considerations in terms of what the actual criminal conduct is. Is this a type of offense where we should require a plea to mandatory life, or should we look at other alternatives?
All right, and Judge Gleason is going to talk a little bit more about mandatory minimums later, but there are mandatory minimums for drugs, for guns, for child pornography. There's a lot of mandatory minimums that allow prosecutors to operate with that discretion. And it can frustrate judges. I'll just say this from a judge's standpoint, then you lose control. You may think there are a lot of mitigating circumstances that would warrant a much lower sentence, and you just can't do it. I did want you to focus briefly on cooperation, because again, I think this is something most people who are not part of the system wouldn't completely understand. But often it's said that the way you can get the lowest possible federal sentence is by cooperating with the government. So can you just take a minute just to explain how that would work? If you were interested in having someone cooperate in a gang case, for example, and what you would require and what they would get out of it.
So for cooperating defendants, what happens there is if something like a mandatory minimum is in play, as Judge Bianco was talking about, if the individual cooperates and provides substantial assistance, that may be anything from wiring up and recording a transaction, a drug transaction, or a gang meeting. It could mean that you're actually going into open court and testifying and giving testimony about the nature of a criminal enterprise, like the Bloods or the Crips or MS-13, and testifying in open court. If you give that type of assistance to the federal government, that's going to enable prosecutors to write what we call a 5K letter, and that will give Judge Bianco or whatever judge is sentencing that particular defendant the authority not only to go below any mandatory minimum if there is one, but also those sentencing guidelines that he spoke about. Those really set a baseline for the judge. And by cooperating, it's telling the court that they are permitted or should consider going underneath that guideline sentence. So it's a huge tool. It does entail for a defendant in the federal system to tell us every single thing he's did. So let's say a defendant is charged with a particular shooting. I've had cooperating defendants that have come in on gang cases, charged with 1 or 2 shootings. And by the end of their cooperation, they've admitted to 40 shootings that they've participated in. They've maybe admitted to murders that they were never charged with that we're able to solve. So on one end, there is this risk to the defendant in that in order to do this, they have to disclose to the government everything they've done. But in turn, and in providing that cooperation to allow us to charge and potentially convict other defendants, they're enabling themselves to get a lower sentence by virtue of their cooperation.
Yeah, and I just want to emphasize when I mentioned the scenario where a defendant comes to court and he could get instant freedom or 10 or 15 years in jail, those situations are very common with a cooperating defendant because the government puts the letter in, the mandatory minimums, if they exist, are gone. But ultimately, the judge decides how much weight to give that cooperation versus what their crimes were. And there's no formula for that. Some people think, oh, the judge will cut it in half, or he'll give you a third, or she'll give you a third. But it doesn't really work like that. But the bottom line is, I think the consensus is, and it's borne out by statistics, that defendants who do cooperate end up with substantially reduced sentences. Now, a lot of times the government's not interested in the person's cooperation. Sometimes they're cooperating a very culpable person who can give them a lot of information, and people will scratch their head like, why is the shooter getting the benefit of cooperation and not, the driver in some shooting? But they make those determinations of who they need for whatever purposes. And again, the judge is not involved in those types of decisions. I did want you to talk, Nicole, also just about sentencing in general. I think our audience would be curious how a prosecutor approaches sentencing. We're going to look at it from the defendant's standpoint in a moment, but how do you decide what you're going to say at sentencing, what you're going to ask for? I think some people may think the prosecutor may go in and put the most aggressive position for the prosecution to quote unquote represent the prosecution in that case. But how do you decide what you're going to say or not say at a particular sentencing?
Yeah, so that's a particular challenge for a prosecutor. And I would definitely say that we do not go in and always recommend the maximum or the maximum guideline sentence. Every case is really looked at individually. And what I think is particularly challenging is not unlike the court. We're also balancing a number of different interests. If it's a violent crime scenario, you may have a victim's family that very much wants an individual to spend the rest of their life in prison. And you may, as a prosecutor, and having weighed everything that comes into effect, the defendant's background, perhaps the remorse he's shown, feel that recommending a lower number is important. You may have a defendant that has stolen a ton of money, but made a lot of efforts to pay that restitution back in advance of sentencing. So I think we also are looking at all of the different factors, and we're really trying to decide what we think is appropriate and just, is going to protect the society, is the actual right result. And we're really trying to figure out what's important to highlight to the court. As a prosecutor, you've often lived with the case longer than anyone else. You may have been there from the inception of the investigation, and determining really what points to really highlight to the court and to emphasize in coming up with what that right and correct number is can be as much of a challenge for us as it is for anyone, because again, there's no magic formula. We don't have a system where it's like, we're always going to recommend the maximum in this or the minimum in that. And we really have to look at each case and each defendant individually and decide what we think is the right and just thing to do.
Do you always ask for a particular number, or it depend on the situation?
Every case is different. So even if you were to take every murder case or every drug case, we don't treat every single case differently. Every case, the facts are looked at are differently, the circumstances, the individual's role in the offense, what they did after the offense. All of those factors go into a particular case and our decision, what that particular defendant's backgrounds are, what the reason for the crime is, what the victim's viewpoints are on the particular sentence. We're going to look at all of those factors to come up with what we think is the right number to recommend.
And are there situations, let's say you look at a defendant pled guilty in a drug case to distributing a kilo of cocaine, but he has a lot of mitigating circumstances, he has no criminal history, he has family circumstances, health circumstances, whatever those mitigating circumstances might be. And the lawyer is going to be asking for no jail time or relatively low jail time. What discretion you have as a prosecutor to, if you think there are some mitigating circumstances, how would that manifest itself at the sentencing? What would you do? When I say, Ms. Boeckmann, what do you have to say? The defense lawyer gets up and says, Judge, we want you to be as lenient as possible for these 10 reasons. What do you do in that scenario?
If we really believe that what the defense is recommending is appropriate, there's absolutely no reason for us not to recommend that same sentence as what the defense is doing. So if we think it's an appropriate sentence, we're not barred in any way for advocating for that same sentence. By and large, we always start with the number that the guidelines come up with, the sort of formula that Judge Bianco started with. We always start with that's the right number to begin with. And then if we're going to go lower than that or higher than that, we want to be able to justify why we're doing that, why we're departing from this number that the Sentencing Commission has come up with. But we're certainly permitted, if we think it's appropriate, to go under that number or over that number, to do so. And we really have to look at all of the relevant circumstances and facts surrounding a particular case.
Thank you. I just want to emphasize that last point, because as a judge, I could tell you, prosecutors, because I'm in and out of those courtroom doors, and they do vastly different things at the sentencing. Sometimes they're arguing very strongly for a particularly high sentence, and other times they come in and the defendant makes a very compelling argument for a low sentence, and I'll ask the prosecutor, and they'll say, we rely on your discretion. We take no position, and they're basically signaling to me just by that alone that they're not particularly concerned about what the defendant is asking for. So the whole dynamics of a sentence can change based upon how the prosecutor approaches it and what they say, or in some instances don't say. All right, thank you very much.